Hi everyone. A recent important but not unexpected case recently was decided down in the 3rd District Court of Appeal called Spaggia Ocean Condominium Association Inc. versus Aventura Management. And for the purposes of this chat, I'll just call it Aventura. What happened there is that a condo association was, as I often say, in the race to the courthouse steps with the lender, and the association took title and owned it for a period of time, after which the bank or the mortgage holder foreclosed its interests. And when the bank went to sell it, the association made demand upon Aventura to pay all of the past due assessments, including the assessments that were due when the association owned the property. And the case on appeal is very confusing and leaves almost more questions than it answers. But the takeaway from the case is that in a condo association, not HOAs, because they're governed by different law and a different set of case law, but in condo associations, if you are on the verge of getting a judgment of foreclosure, you should very carefully think about whether that is the remedy you want to elect. Because if the association takes title and is not able to rent it for a substantial period of time, then it probably is not cost effective to do so, because by doing so, what you do is wipe out your ability to collect what are called the safe harbor amounts that a foreclosing first mortgage holder would otherwise have to pay. That is 1 year of assessments, or 1% of the original principal amount of the mortgage. The case is important because it doesn't really deal with there's some confusing language dealing with the ability of the association's lien to survive, and I think the court either got lost in the weeds or left out the word doesn't or didn't or something. But it's hard to tell what the court meant, even with the pretty well-reasoned dissent. But the bottom line is that unless your condominium association is in a position to be able to take the property back and rent it, and you feel after dealing with your counsel that the association is going to be able to recover after it takes away the monthly assessments that accrue while it's owned by the association, enough to cover the loss of the safe harbor amount when the mortgagee takes title, then I strongly recommend that you consider perhaps obtaining a money judgment against the owners, in which case you can either seek to chase them, for lack of a better word, or maybe obtain the foreclosure, but perhaps form a subsidiary corporation, such as banks do when they take title, to hold the real estate they own, in which case that wouldn't interfere with the ability of the association to collect the safe harbor funds, but that opens up a whole host of other issues. The bottom line is that this is a case that we're all going to have to take a deep look at all of the condominium association foreclosures, what the status of the unit is it rentable, has it been reviewed in order to determine whether the association, by using its irrevocable right of access at reasonable times for purposes of determining whether there's damage occurring to other units or the common elements, to be able to see if the unit's in good shape and to make sure that it's not damaging other units, in which case you can make an educated guess perhaps as to the ability of the association to rent the property, what your rental restrictions are, and whether you even want to be in the business of renting, which most associations don't, or whether maybe there's an investor who will come and give the association some minimal amount of money for the purpose of being able to rent the property, or even assign the bid to between the time of the sale and the issuance of the title. What's the bottom line? It's no different than it's been since I started practicing this field of law in 1982. You are in a race to the courthouse steps, and I'm all for compassion, but you need to make sure that you carry out your duties to your fellow owners and your fiduciary duty, which means you're in a position of trust and confidence, and that you not dally when it comes to obtaining such relief as may be necessary in order to protect the interests of the association, and move quickly, because average foreclosures are still taking 700-800 days, and there may be an opportunity for you to be able to turn it around, but it's not for everybody. It's not for amateurs, and you sure shouldn't do this without checking on a case-by-case basis how you're going to handle it. Maybe there is some relief coming in the form of a proposed bill in the legislature, which will allow associations to intervene. Actually, you're already part of it, but it will allow in the mortgage foreclosure cases, there's case law that's held that the association doesn't have the right to push the foreclosure. It's up to the plaintiff. If this new law is passed, then the association will have the right to move it along. You can always decide, even now, to set the mortgage holder's case for trial. So there are certain things you can do that are maybe what I would call a least horrible option than what we used to have before the roof fell in 2007, and when we used to have best options. But work with counsel to choose your least horrible option. If you have questions and you're a client of this firm, or even if you're not, feel free to contact me. As always, this is intended for friends of the firm and current clients, and is not meant to be a solicitation or a commercial or anything like that. If you don't want to receive these updates, let me know and I'll take you off the list. But this was important enough for me to make this special video, and I thought it important to share with you. Thank you.